Hello, everyone. Today I'll be discussing a significant employment law case involving wrongful dismissal of five Go transit bus drivers. This case highlights violations of the employee policy and the employee privacy rights and how Canadian law protects off duty conduct. So, in this video, I'll be answering the few questions that we are supposed to answer. Talking about the very first thing, I have included the link here from where I found that article and the brief description of the article. And for the references, I have used the class notes and the presentations only. Moving further to question one, what did the employer do wrong in this situation? So, as stated in the article, the off duty activity that was forming the WhatsApp group by the employers was one of the reasons why the company fired the workers, violating their right to privacy and freedom of speech. The problem was that these were the private talks and that had nothing to do with the business, and I feel that this shouldn't have been grounds for dismissal because the employers themselves doesn't do anything wrong. And now moving to the second question, what law did the employer violate? In this case, the employer broke the privacy laws. How and why? um Under the Canadian employment law, employers cannot discipline or dismiss employees for off duty conduct unless it directly affects the company or the workplace. So, just because the drivers were having the private conversations, it didn't impact to their work, and therefore their termination was unjust. Moving on to the third question, what should the employer have done in this situation in order to comply with the law? So, I feel that the employer needs to have honored the workers' rights to privacy. He would have gone through a different approach rather than just terminating it because it was not something related to their performance. And if there had been issues with uh, anything related to the workplace, then it would have been necessary. But since it was not affecting the workplace directly and it was just about the privacy of the workers, then then it would have been better to resolve these internally rather than just firing that away and without being respectful about their privacy and conduct. Now, moving on to the last question, what legal remedies are available to the employee in this situation? So, in this case, the drivers appealed their termination and won. The tribunal ordered their resentment, showing that the wrongful dismissal can be challenged. In such cases, resentment and compensation for lost wages are typical remedies for employees who are wrongfully dismissed. Because with an emphasis on their work to privacy and freedom of expression outside of work, the drivers was rightfully restored. So, in conclusion, I can say that this case demonstrates the importance of respecting employees' privacy and shows how any off duty conduct, when not related to work, is protected under the Canadian law. Thank you for listening, and I hope you got the concept.